Speaking also to the amendment, Count Corley, it's difficult sometimes with criminal law to have a rational debate without having to listen to the manufactured outrage of some people trying to prove that they're tougher on crime than others. And I remember being on the JPC in Kerry, and no matter how many times the Chief Superintendent would come in and say that Kerry was the jewel in the crown and had much lower crime rates compared to everywhere else, it didn't stop people coming in and claiming otherwise. As an Iron Bevan used to say, if you don't have a programme, a bogeyman will do. And unfortunately, raising a bogeyman, we've heard some of it today, in fact. It's the duty of an Garda Síochána not only to eliminate crime and the causes of crime, but also the fear of crime. And too often, that's forgotten. It's difficult to underestimate the importance of the lawful judgment of one's equals or the jury system in the administration of justice over the years. Juries, as we know, evolved from the Magna Carta, which first acknowledged the rights of the people as opposed to the rights of the Crown in England, and evolved to what is the jury system today. It's a necessary safeguard or bulwark against what is perceived sometimes as state oppression. And if a jury, I've seen over the years, feel that something is not quite right about a prosecution case, they're entitled to throw it out. And I remember Judge O'Higgins, who used to operate in the South Western Circuit, taking off his peruke or his wig, throwing it over at the jury and saying, it's up to you, you make the decision. And it's a decision that the juries do not take lightly. In Ireland, of course, there was military courts, special courts, introduced in 1939, expanded then in 1972, as we can remember, in controversial circumstances, where the government reasserted, as they were required to do under the Constitution, that the ordinary courts were ineffective to secure the proper administration of justice, and the bogeyman of jury intimidation was raised. Jury intimidation is like the weapons of mass destruction of the Irish criminal justice system. It's very easy to raise this, but where's the evidence of it? Is it in any of these reports? Has it ever been mentioned? Most of the Limerick gangland cases were dealt with a jury. Many of the Crumlin Drimna cases were dealt with a jury. And is there any evidence of any intimidation which led a jury to acquit somebody? I haven't seen it. If there was any evidence of jury intimidation, it could form part of the proposed review, but there doesn't seem to be any. In 2014, the Irish Human Rights Commission said there was no supporting data to support the view that the ordinary courts were ineffective. And to say so, in my view, is a disservice to the Garda Síochána, the courts, the judges, and also to the members of the public who sit on juries. Guards need resources rather than hyperbole. More and more over the years, there's been a creeping expansion of non-jury trials, and the UN Special Rapporteur said the seepage of the exceptional for emergencies into the ordinary has become the norm. This is in ways that has not served the rule of law or the protection of human rights. The UN Committee of Human Rights previously said that the continued existence of the special was not justified. Irish Council for Civil Liberties, Amnesty International have called on successive governments to abolish the Special Criminal Court. The Hederman Committee, we've already heard about that a pressing case to abandon the jury trial had not been made, was the view of Mr Justice Tony Hederman at that time. By the way, it's important, if there is any review, speaking from a local point of view, in any review of the courts, we should review how many of our district courts have been closed over the years. This century, in Kerry alone, we've lost at least 6 local courts where justice was administered. And now, if you receive a summons for an offence in Castlemaine, you have to go all the way down to Carsavine to go to court. And I hope that this current COVID crisis isn't used by the court service to close more courts or restrict facilities, particularly maybe in the courthouse in Tralee. Just getting to the contents of the motion, many of the provisions in it aren't used. In the 1998 Act, Section 6 has been used twice in 20 years. Section 9 is routinely used in the ordinary courts and does nothing to prevent the intimidation of witnesses. That can happen anyway. It's nothing to do with whether it's in the Special Criminal Court or in any other court. In dealing with Section 8 of the 2009 Act, which states that the ordinary courts are inadequate to deal with certain provisions, Section 71A is almost impossible to prove and is rarely used, while Section 72 accepts that it's essential in the battle against organised crime. But the ordinary courts should be well capable of dealing with them, similarly with Section 73 and 76. In relation to the review that has been proposed by the Minister, and I'm glad that he has, the Oireachtas deserves better in this review than a 6-page report which was sent the day before yesterday expecting a rubber stamp of this legislation. Repeating really what the Commissioner has told the Minister. There's no assessment, there's no critical oversight by an independent body, there's no chance to discuss the issue, before the Justice Committee, and this is going to have to change in any review, especially when such rights like the right to silence and extending powers to keep citizens for longer periods in Garda Station are being extended. The review is going to have to be comprehensive, and we should at least make some effort to reduce the need for non-jury courts. We can consider screening juries, we can locate them in other rooms. We've neglected to consider over the years any type of intermediate measures whatsoever. We go for the nuclear option. Just finishing now, as things stand, the DPP has total discretion. He should be required to provide reasonable, objective reasons why a case is being sent to a non-jury court. Two people could be charged, one could go to the special for the same offence and the other could go to the ordinary courts. This evidence should be, rather than being speculation, should be provided to defence and court. In England, you have to make an application to a jury for a non-jury trial. It must be made, maybe in private, but before a High Court judge. Something like that is what we need. There must be a review after all these years. Thank you.